Your medical records were subpoenaed into court for the purposes of your upcoming trial. Now you're at trial and you've got a break. You want to go ahead and look at those medical records that were now subpoenaed into court. Can you do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is no, you cannot do that. You want to know why? It's because if you were to now sit down at the attorney's table and go ahead and start looking through your own medical records, you would be breaking the chain of custody. And why is that important? It's important because when we introduce those medical records into court, into evidence, we have to ensure that there is no broken chain of custody. So what does that mean? It means that when we subpoena medical records into court, we want to now be able to say that the hospital or the doctor's office now has certified that these are accurate, true, and complete medical records of your particular condition. Now, those records get sent into the courthouse. And now, at the time of your trial, the court officer or the attorneys will bring those records up to the courtroom to be able to use at the right time. When we want to use those medical records to introduce into evidence, we have to show the court as well as our opponent that these records are certified as being accurate, true, and thorough. We have to do that, and there are different ways to do that. We have to show that there's no gap from the time it left the hospital to the time it got to the courthouse, to the time it got to the courtroom, to the time we're now introducing that into evidence. Why? If there is some gap between the time that those records left the doctor's office or the hospital and now they get introduced into evidence, my opponent could turn around and say, Judge, the plaintiff, the injured patient, went through those records, and there's the possibility he took records out. There's the possibility he crossed things out. There's the possibility he altered those records. Whether you did or not, now he's raising that possibility. Why? Because he saw you sitting at your attorney's table, rifling through those pages, trying to read them quickly, because you were interested, because you were curious. You wanted to know what they said. And the moment you do that, now the defense has every opportunity to raise the possibility that you might have altered or removed or taken or done something to those records that now has altered the chain of custody to show authenticity, to show that these are complete, to show that these are accurate. So the moment you insert yourself into that chain of custody, now you raise that possibility, which raises a whole can of worms that you don't want to go into. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice trials, these accident trials, and even these wrongful death trials here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.